Blogging and other social media is incredibly influential, not only to customer bases, but also people's perceptions of your business, marketing issues. People use Facebook and other types of social media for recruiting and marketing and all sorts of tools. There are 3.5 billion users, companies that have their own web pages, and sometimes it's the only web page they have is on Facebook, and not, monitoring their own web page, simply because it's easier to just have everything on Facebook, because most people are on Facebook. Now, maybe the young folks are not so much, but generally speaking, most people are. And there are about 500 million blogs as of 2020. People blog all sorts of things. We have to recognize there's a difference between a blog and a sort of a peer-reviewed article. People often use blogs as a way of supporting their arguments for things, when blogs are not always rigorous and critical in their way that they do things. Password protection statutes limit access to an employee's page in the majority of states, and as of 2019, and it's actually become sort of a non-issue for most employers. Most employers don't really care about people's social media unless it's publicly accessed and have access to it, and then they can see whether or not someone's engaging in a behavior that they might deem inappropriate. For example, if you want to work for Anheuser-Busch, you cannot be seen drinking anything but Anheuser-Busch beer, and they will sue and they will fire you if they see you drinking Miller Lite. So don't make the mistake in going to interview for Anheuser-Busch and saying, "Oh yeah, I like to drink Blue Moons," because Blue Moons are Miller, and Anheuser-Busch does not support Miller. So, there are some things that an employer can ask of you and require of you, and they can monitor that. There are, of course, collisions of employer interests and employee rights when we think about trade unions and some of the issues there, public sector free speech. But we have to balance those rights. A good case is that City of San Diego v. Roe. The employer social media policy recommendations should be that objectives should not overreach. So you want to have your objectives for what your policy is, but not try to be too controlling, because unfortunately, if you become too controlling, that becomes a larger issue. You want to have a reminder that the company policies apply, and remind people this is what our policy is, and it has to be investigated and continually applied consistently. There are personal comment rules, what we can comment on, and that there are some freedoms in what we can comment on. Disclosure, monitoring, and copyright reminders are also really important. So what we can disclose and what we can't disclose on social media, whether or not we are monitoring things, and whether or not we're sharing copyrighted materials. We also want to make sure that our people, when they're putting together presentations and website stuff, that they're not using copyrighted materials on social media for the company, so that it limits, right, the ability to it limits your ability to present information on a website that might be violating copyright rules. And also, are comments okay from people, and how do we handle comments? For example, comments that might be discriminatory on our website. There was a big controversy not long ago on the SIUE Facebook page, where they were posting pictures of the stone in the middle of the SIUE campus that a lot of groups paint, and one was painted for June, which was Gay Pride Month a couple of years ago, and there were people on the social media site making negative comments about the stone, and was that appropriate, and being anti-LGBT. And there was a huge issue on campus as to how SIUE should handle it. And in the end, the SIUE decided that if they're going to be anti-racist, and if they're going to put their money behind the idea of being protective of diverse opinions and diverse ideas, on the one hand, diversity and equity and inclusion requires them to be welcome to all points of view, but not necessarily in a way that creates a hostile environment or denigrates other groups. Right? You can agree that I would never be in a same-sex relationship. That's fine. Your religion decides that. That's fine. but you cannot say, I think they should be put to death on social media, because that then starts to violate people's rights, right? Within the boundaries of the organization can decide what they want to allow and what they don't want to allow on that. So there's such a fine line about how we have to protect free speech on the one hand, right? And also at the same time protect people, because if you're going to stand for DEI, you need to be able to stand up and say, these are issues that I will not allow to continue, right? I won't allow someone to denigrate my coworkers or my Black employees or my gay and lesbian employees, etc. There have been some inconsistent court results regarding disciplining of employees due to off-duty blogging. So it's hard to know what the courts are going to argue one way or the other. There are few state and really no federal statutes that provide reliable protection. So deucing was a big one, right? Where someone was anonymously posting about their company and they got caught and then they got fired, and the courts supported it, right? So we want to train people properly in how to engage in blogging, and if people are engaging in blogging, how they handle that with respect to talking about the company. And it can be monitored, and so it's important that people recognize that. I mean, what's the point of blogging if it's not open to the public, right? I mean, the whole point of blogging and other Web 2.0 stuff is that it's public and it's available for people to see. So, so you run the risk, obviously, of losing your job because you might be talking negatively about your employer. So employer social media policies should have, again, defined objectives that don't have overreach, that there should be legitimate business interests involved. It's a reminder that the company policy is where it applies, and make sure we do this regularly and consistently. Talk about the personal comment rules, as we talked about, and disclosure, monitoring, and copyright reminders always. Same things that we talked about before when it came to email and social media stuff. The same thing with blogging. In terms of waivers of privacy rights, there are some limitations to them. You can't have a waiver that truly invades somebody's privacy. So you can have them, though. It's about physical invasion of personal space and belongings and body. Under what conditions would you waive your privacy rights, etc. So they have to be very clear. There are very clear conditions about when we would do that. A waiver is basically intentionally relinquishing your right to something. And can do that at all stages of employment. Courts don't like them so much. Requiring a waiver, it should be knowingly and intelligently given. So the waiver needs to be clear. So let me take you out of the workplace, but think about Facebook, right? And Facebook has all these legal waivers in the very beginning when you join Facebook, and they say blah, 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 and we're going to use your data and stuff. But no one reads it because it's unreasonable to expect that someone's going to read a 20-page, legal waiver that says we have the right to do all this. So there's been some question as to whether or not some of these waivers that are in legalese, right, are understandable by the average person. Since we know the average person barely reads beyond an 8th grade level, how do we protect people, right? How do we protect people so that when we say a waiver is knowingly and intelligently given, how do we guarantee that? How do we ensure that people actually have understood what the waiver is about? The waiver requires what we call a consideration, which means that if I'm waiving my rights, that means I gain something from you. I'm waiving my rights for X, and you are going to give me something in return for waiving those rights. So it has to be there has to be a give and take, right? I give, but I'm going to get something in return for that. At the applicant stage, contingent offer is considered a waiver, right? It's like it's a contingent offer, but I have to pass certain background checks. I have to make sure that I'm not engaging in passing a drug test or passing a background test and things like that. At the employee stage, there's some other considerations, right? I will give up my right to privacy, but I will gain perhaps a higher pay or something along that line because of the higher risks involved in the job. There's all sorts of things that we can be writing into that. In terms of our privacy rights since September 11, the USA Patriot Act and the USA Freedom Act both expanded states' rights with respect to internet surveillance technology, and it's granted access to sensitive data with only a court order rather than a judicial warrant. And this was, of course, a big issue after September 11th and the terrorist attacks of the World Trade Center towers. And even as a survivor of 9/11, I can appreciate why that would need to be done at some level. But I think that there was a lot of abuses that happened, and I think that there was an overreach, in my personal opinion. And many of these constraints have not been renewed. And so there are some concerns, and we may see some of these things rolled back. It's hard to know. Government is now allowed to really monitor anyone on the internet by contending that that information is relevant to an ongoing criminal investigation. So it can request employee data. The employers may cooperate, or they may ask permission to seek the employer authorization. They may have to request a subpoena or a search warrant or a Freedom of Information Act in order for that. So, the government can do this, but whether or not they should be doing it. The issues, for government security is not, daily internet use, right? It's people that are violating their visas. That's where the problems are. But again, there are some cases where we have to, clearly monitor what's going on, and there may be some issues involved. We just don't want to be using it inappropriately, where we are, on a witch hunt like we were during the 50s and McCarthyism, right? Where anybody who spoke out against the government was considered to be criminal. That's where that line gets drawn, and we want to be careful of not repeating that behavior, because that was a very bad situation at a bad point in time. So we want to be careful in allowing that monitoring to occur. As I said, many of these issues have not been renewed, as the act has sort of phased out, but that there are still elements of it that are still relevant today in the workplace. We now enter into the long laundry list of management considerations, always important. There's 4 slides of these. Number 1, we want to make sure that we're developing and publishing policies that reserve our right to monitor people where appropriate and with business necessity, that we have the right to gain access to and disclose emails in the system. So the employer has the right to this information, but we need to make sure it's communicated clearly and used only in the scope within which we have agreed to use it. We want to ensure that any policy that applies to emails also applies to instant messaging. We want to make sure we're enforcing privacy-related policies consistently, updating our policies regularly as the law develops. We want to ensure that the privacy policy extended to Web 2.0 technologies and that strikes the balance between appropriate and inappropriate use. So we have to be clear where it's appropriate, where it's inappropriate. We want to make sure our privacy policy is clear so that employees have no expectation of privacy in employer-provided equipment, all employer-provided equipment. So if you're using an employer-provided equipment, that there is no expectation of privacy, period. If searches are contemplated, clearly state the purpose, the conditions were conducted, and that searches will not be conducted as fishing expeditions. So we're not fishing and you never know what you're going to catch, that there has to be a very clear purpose behind it. We want to make sure our monitoring policies are clearly stated and consistently carried out, and when we're monitoring and we have to follow through on it. We have to make sure that if we've monitored and we've seen a harm or we've seen inappropriate behavior, that we follow through as our policy states. Otherwise, the employer then is in liability. Avoid content-based and real-time monitoring. We want to make sure also that we're tailoring our policies to account for variations in state and federal laws. State laws are going to differ very clearly from state to state on these monitoring policies, so it's important. We We want to make sure our privacy policy is targeted to protect our business interests, whether we're using cameras or cell phones or other devices for making recordings in the property, the use of emails for distributing illegal, improper content, the use of company trademarks, logos, and other copyrighted material without permission, and the disclosure of company materials to outside entities. These are the essential things that we are protecting. It's our competitive advantage, and an employee does not get to abuse that or illegally use it for their own gain. Regarding off-duty activities, be wary of over-restricting. Again, not every company can get away with saying, we don't want people to smoke. No, we want people to be healthy, and therefore, they can't be overweight. These are that's overreach. We want to consider focusing on activities with possible negative impact on our business interests and on the public's perception of the employer. So our goal is, what business interest does it have an impact on, and what public perception will it have if we allow this behavior to occur? So as long as it doesn't impact us in that way, it doesn't affect our business interest, doesn't affect public perceptions, then we probably shouldn't be monitoring it. Lastly, regarding waivers, are there less likely problems with a waiver of privacy rights where the waiver is accompanied by an offer of employment or some other compensation if later required? The quid pro quo. You will waive your privacy rights and you will get this in exchange for that. So we want to make sure we're clear there. Ensure that you comply with all privacy rules regarding HIPAA, which is the Health Information Privacy Act. Safeguard collected data, regulate access to information, make sure that we don't have unwarranted disclosure that can be considered an invasion of privacy where we're collecting information on people. Be aware of the GDPR, nascent state and federal statutory duties regarding data collection and management. So we want to make sure that we are not violating any federal laws or state and federal statutory duties on how we manage data and how we collect data.